Hello, and welcome to another episode of Jurors in Disguise. My name is MaryRose Peterson, and I own Covert Ops Jury Investigations. What do we do? I'm glad you ask. We search for jurors who lied during jury selection so they would be chosen for the jury and ensure our client's conviction. In this podcast, I'm going to talk about another one of our cases, one of our very first ones that continues to be very dear to my heart. And I don't want to be like the TV evangelist who gets accused of crying every single time on cue, but you will find that our clients become family to us, and their cases are deeply personal. In this particular case, we were contacted by a mom who lives in Alabama. I'm not going to use last names, but her son's name is Christopher. And he had gone to trial and lost. They had tried a lot of different things to argue his case, and it was just continually denied. So she saw us on Facebook. We had started a Facebook page called Families Overturning Jury Verdicts. So she found us there and reached out. I got to hear a little bit of their story and was very touched by not only her love for her son, but her grandson who was involved in this case. We did not have a copy of the jury voir dire. We were able to track down the court reporter from 5 years before that was there at trial, and we were able to get the jury voir dire transcribed. It had never been typed out. So that's one thing to keep in mind. The courts are arguing that you could have found it sooner, but without the jury voir dire, we have no way to prove juror misconduct. So we can't take a case where there is no way to know what the jurors were asked the day of jury selection and what answers they gave. So without that document, I told Chris's mom we would not be able to do anything for them. But we were able to get that from the court reporter, which was very exciting. In fact, I have an email here on November 12th from 2019 where I wrote to Chris's mom and I said, "Hey, great news. Our court liaison talked with the court reporter who took down Chris's voir dire. The proceedings had never been transcribed, but we ordered it from her. She said it will take her about 2 weeks." Well, needless to say, his mom was thrilled, as were we. And I have to just interject this. Well, I don't have to, but I'm going to. Every time I got an email from Chris's mom, it made me smile because at the top of every email, there is a quote of hers that apparently is a favorite from John Wayne. And it says, "Life is tough. It's even tougher if you're stupid." So, what does that got to do with this? Nothing. I just thought it made me laugh every time. So, we got the transcript. And then Martin and I actually drove to Alabama. This was back in the day when we took one case at a time, and I had remote investigators working with me, but we were um, we were able to take the case because we had the voir dire, but the what complicated it was that the clerk of court had no records online. In fact, to my knowledge, they still do not. Everything is kept there in-house in the courthouse, which is another reason why arguing that this could have been found sooner is pretty much ridiculous because you would have had to physically go there. And well, first you'd have to know to even investigate the jurors. And of course, Chris couldn't have done what we did because he was in prison. So we went to the courthouse and I spent about 3 days going there in the morning. Martin would drop me off and he'd go back to the hotel and hang out. And I sat there outside the clerk of court's office on their very antiquated computer, looking up records of the jurors to see what was in there that we could use to find juror misconduct. Every time I found something that I wanted, I would have to go then around the corner to the clerk of court's office and order it from them and then pick it up the next day and pay for it. So clearly, this is not something that someone incarcerated could ever do. And it's not something that most people would know to do. Even if someone told you you could investigate the jury, there's very little chance that you would even know to reach out to a court reporter. I know to do that because I used to type for court reporters. So I understand how integral they are to our system and keeping good records. After just a few days, I was convinced that we had found information on the jury foreperson that was not only concerning, it was jaw-dropping. And from there, we were able to then combine all the other tools that we use on the internet, such as social media. And you'll read, as I read, you'll find a little bit more of some of the tools that we used to be able to prove juror misconduct in this case. The similarities between Chris's case and the specifics of it and what we uncovered is you could almost superimpose the cases on top of each other. They were so similar, for lack of a better word, that it really shocked me, and I'm not easily shocked. This is one of the cases I feel was very very strong evidence of juror misconduct, as you will see. We investigated the jurors, and then I wrote a report. February 5th of 2020 is when I wrote the report of findings. And I'm going to start out, like I have before, reading you portions of the voir dire transcript, because to me, it's very important, and enough that I put it in my reports. It's important for you to get a feel for, if you were one of the jurors, prospective jurors sitting there that day in the courtroom, what are some of the things that are being said to you as you're sitting there having shown up for jury duty? It's important that you understand how the court, meaning the judge, and the attorneys set the case up for the prospective jurors. So on August 11th, 2014, the voir dire was conducted in the Alabama courthouse. At the beginning, honorable, I'm sorry, I get hung up on that words. I'm going to say this at the end too. If there's a judge out there who is honorable and does the right thing by anyone accused of a crime, who is not biased, as you'll think back maybe of my podcast from last week, I would really love to talk to you. I would like to meet a judge like that. I've met one. Honorable Michael T. Jones addressed the prospective jurors. Here's what he said. I'm going to ask you some questions that touch upon your qualifications to be jurors in this particular case. You remain under the same oath that you were given earlier for purposes of my questions and for purposes of the attorney's questions in what we call the voir dire examination. It is very important that you listen to the questions and fully answer the questions. Parties to a case are entitled to true and honest answers to these questions, and the fairness of the jury system depends on true, honest, and complete answers. Okay, if I'm sitting there, I'm a prospective juror, I've just been put on alert that I better tell the truth. When the Assistant District Attorney Chris Connolly addressed the veneer, he said, "What we are trying to do is find 12 people that can be fair and impartial and call this case right down the middle based on the evidence they hear from both sides of the courtroom and also the law that the judge is going to give you at the end of trial. Because of the nature of the case, this man is charged with sexual abuse of a child under 12. Some of these questions may be uncomfortable. They may pry a little bit into some personal lives. We are not trying to do that intentionally, but we are obligated to do that so that we can make sure that we get 12 fair people on the jury." And again, this podcast is not for children. He continued, "So if I ask you a question that makes you feel uncomfortable, or you just don't want to just stand up and tell your business all out in the courtroom, just acknowledge that and the judge can talk to you as privately as we can in chambers." He also said, "Is there anybody on the veneer," that means the jury pool, prospective jurors panel, "who has ever had a fight with anyone?" Please pay attention to this. This is important. He didn't say that. I said that. "Is there anybody on the veneer who has ever had a fight with anyone through social media, like through Facebook or Twitter or email, back and forth, or anything else like that? Or it may not be a fight, but even just words like a heated discussion or anything, anyone at all?" No response. Nobody. Is that one of the questions you don't want to talk about out loud? All right. Even private messages don't have to be open to public. You know what I'm talking about. Private messaging on Facebook and all of that. Anybody at all? Nobody has gotten into a fight with anybody over Facebook or Twitter or anything else like that? Then he said, is there anybody on the veneer who has yourself, a close friend, a family member who has been involved in any kind of domestic or divorce proceeding where Twitter or Facebook or tweets or messages were an issue? Anybody at all? Well, this time one juror did speak up. This juror told about how his sister-in-law's ex-husband posted a lot of information on Facebook during their divorce. But the jury foreperson, or who would become the jury foreperson, said nothing. After this prospective juror said what he did, the assistant attorney said, that's exactly what I'm talking about. When I say gotten into a fight or dispute or issue on Facebook, that's kind of what I'm going for. Where people started trash talking on Facebook, was there any harsh language used? Cuss words? Derogatory comments? That kind of thing? People get all kind of heated on that kind of stuff. Now, this is throughout the voir dire. These are the questions that he keeps coming back to. He said accusing each other, stepping out on each other, and that kind of thing. So that kind of back and forth. Is there anybody else, either yourself, a family member, or close friend you just know about, somebody you just know about, has had an experience similar to what that gentleman right there just described? Anybody? Another prospective juror spoke up and told him about her family's experiences, but the soon-to-be foreperson said nothing. The attorney continued. Lots of unpleasantness going back and forth on Facebook and emails and text messages and that kind of thing. Anybody? There may be some evidence in this case that is used from Facebook messages or emails or text messages to attack certain witnesses in the case. Is there anything about your personal experience you had with that type of Facebook messaging that you would bring with you into the jury box if you were chosen as a witness, as a juror in this case? Y'all can kind of see where that was going, and I kind of started generals. Anybody had words and fought on Facebook, and we've kind of had 3 different examples we've talked about. Does anybody think that it is more common these days to do this type of thing on social media? Who agrees with that general proposition? Several hands were raised. All right, he said, now anybody else want to be brave and talk to me about that? Apparently not. Then he said, these are serious allegations both ways, and we want to make sure we get 12 fair jurors that don't have an axe to grind about anything. Got a few more of these personal sensitive questions. Is there anybody on the veneer who has had to deal with a serious domestic violence type situation? Anyone at all? Is there anyone on the panel, any of y'all, who've had to live through or deal with that because of friends or children or whatever? Any type of domestic violence type situation, domestic violence related situation? Anybody? At that point in the proceeding, a prospective juror, who was later not chosen for the jury, spoke up about a man who came to their home, bashed in her car, threatened her and her daughter. This resulted in 3 charges of domestic violence against the man, and the family was granted a protective from abuse order. The soon would-be foreperson said nothing. Another prospective juror, who was also not chosen for the jury, spoke up about a patient of his who had injuries who he suspected were a result of domestic violence. He confronted her and she denied it, but later returned with similar injuries. This prospective juror, soon-to-be foreperson, said nothing. And yet another prospective juror, who was not chosen for the jury, spoke of seeing his mom getting beat up all the time, he said, when he was a child. This would have been another perfect opportunity for the foreperson to speak up, but she chose to conceal her bias and remain silent. The last thing that the state attorney said was, anybody else need to respond to that domestic violence question? Anybody? Next, the defense attorney addressed the veneer. His name was John Mays. He said, "Now I'm going to get personal on some things, but these are issues we really need to know about. I would like to know if any of you have ever been in a relationship with someone and that relationship started to go bad, and then that person did everything they possibly could to embarrass and humiliate you. Have you ever had a really bad relationship where the other party just goes out of their way to act ugly, to embarrass you, to humiliate you, who maybe humiliate your friends and maybe the people that you know? Anyone? Have any of you ever had a close friend, maybe somebody that you started working with or to go to church with, or a neighbor who's been in that kind of a relationship, that you saw any evidence of that kind of a relationship?" Several prospective jurors spoke up and were struck. The foreperson said nothing. Then the judge, Judge Jones, readdressed the veneer. He said, "All right, ladies and gentlemen, you were told that you would be given an opportunity to answer questions in chambers to anything that was asked that you did not feel comfortable in answering in a public forum. And I know that several of you have identified yourself as people who need to take advantage of that. I need to see Ms. Butler, Ms. Watkins, Ms. Owen, Mr. Richardson, Mr. Rippey, and Ms. Wiley. Is there anyone else who needs to see me in chambers in response to a question I ask or either of the attorneys ask? Anybody whose name I did not mention? All right, well, one more, Miss Childers. Anybody else? No." These prospective jurors exited the courtroom. They went and spoke with the judge and the attorneys privately. The foreperson waited around with the other members of the veneer for them to return. At no point in time did she speak up about her own experiences. These are some of the things that we were able to uncover about this foreperson. I'll call her foreperson Ashley. Just a year before Chris's trial, she filed for divorce. In her petition for divorce, she stated that she and her husband had separated a month before. Now, this was again just 1 year before Chris's jury trial. On page 2 of the petition, she said, quote, "The husband is continually harassing and threatening the wife, and that it is necessary for the court to issue a restraining order to prevent the husband from sending harassing and threatening messages and disturbing her with calls and text messages all hours of the day and night, bothering her at home or any place she may be." And she asked the court that the husband be ordered to not harass or threaten the wife, either by calling or texting or bothering her at home or any place she may be. Seems like they asked that question multiple times. Then, just 10 months prior to Chris's trial, an order was issued granting her an injunction against harassment. Both parties were ordered to not harass, intimidate, molest, threaten, or assault the other, either directly or indirectly. Additionally, neither party shall do or say anything to minor children of the parties or in the presence of the minor children to influence said children about the other party or about any issue presented in this issue. Now, I will add that at that particular time, this jury foreperson's daughter was about the same age as Chris's son. That's important. Juror foreperson Ashley had a best friend. Her name was Jamie. They admittedly have been friends since before Chris's trial. One of the things we were able to find on Facebook, and we included these as exhibits, are multiple pages in both of their Facebooks of the two of them together. Very good friends, best friends. They considered each other sisters. Very good friends. And we don't always put so many. I'm not going to show that one because it has their daughters. They both had daughters around the same age as Chris's son, who was named in this case. Lots of pictures, more pictures and pictures and pictures. And then we found one that I submitted as Exhibit S, which it's a little hard to see, but it has the jury foreperson and her best friend and her best friend's mother, who considered her a daughter. So the three of these were, as my mother would say, three peas in a pod, two peas in a pod. They were besties. So four-person Ashley's best friend Jamie, who you just saw pictures of, was also in a violent relationship. She had been married. They, like I said, they had a daughter. And then she filed a petition alleging abuse. And she said that her husband stalked me, made me afraid that I would be seriously injured, came to my home, my work, my parents' house, tried to force entry in my home, and kept coming after told to leave. She also indicated in the injunction that that he attempted, threatened to, and caused her bodily injury. He stole from her, stalked her, and restrained her. It was only a few minutes ago, but I do remember them asking questions that sound very similar to that, asking if anyone had any experiences like this, and four-person Ashley said no. She said no by her silence. In every investigation, we make public records requests of law enforcement agencies everywhere the jurors and their family have ever lived to see if there's anything that they have on file that might add to what we are finding in regards to juror misconduct. In this particular case, we asked the Florence Police Department if they had any records on either of these two women and their husbands. Sergeant Cliff Billingsley of the Criminal Investigations Division wrote a report, and he said, quote, "I received a call from Jamie stating that someone was calling her place of employment and asking for her. The number that showed up on the caller ID was her ex's. He had visited her place of business and asked a coworker if she worked there. Jamie came to the police department and stated she wants to press charges because she wanted him to finally leave her alone. She advised that several text messages have been sent to her by the number. Some of the text messages were rude and some were apologetic. Jamie assumed they were from her ex because of the phone number. A few months later, a grand jury met and found Mr. Smith guilty of harassment. In the indictment, they said, quote, "The grand jury of said county charged before the finding of this indictment, Mr. Smith, whose name is otherwise known to the grand jury, did with intent to harass, annoy, or alarm another person, to which Jamie, strike, shove, kick, or otherwise touched a person, to wit, Jamie, or subject her to physical contact and or communicate with the said Jamie in a manner likely to harass or cause alarm." I believe they asked that question. Four-person Ashley said nothing. A few months later, there was another petition for protection from abuse where Jamie alleged more things in regard to how she was being stalked and treated. Um, the order was granted. Now keep in mind that her ex, Mr. Smith, that this case was ongoing at the time of Chris's jury voir dire, and yet juror Ashley said nothing about it. Juror Ashley, like I said, is also friends with Jamie's biological mother, and she too had a violent marriage and divorce. And her petition for divorce, she alleged, quote, "The husband left the premises with the 2-year-old son, advising that he would not return the child until he received service from the court ordering him to return the child. There were 2 children born of this marriage, and that prior to leaving her, he shoved her around with his hands about her head and threw some articles at her. He cursed at her and indirectly threatened to do additional bodily harm to her." But four-person Ashley doesn't know anyone who's had domestic violence in their past. If you were Chris and you knew that this juror was going through it at the time that she was sitting on your trial, and then became the foreperson, knowing that her best friend was going through it, knowing that her best friend's mother was divorced because of domestic violence, is that the type of juror that you want sitting in judgment fairly and impartially in your case? I think not. But that's who he had as his jury foreperson. And as I've said, I was a foreperson one time. You carry a lot of weight in that deliberation room. Your opinion matters. Why? Because most people don't want to be there. Most people want to vote guilty and go home. There are very few times I know of personally where a jury actually deliberated. Most of the time, they just want to eat their state paid for lunch or dinner and go home. So this foreperson who lied all through the voir dire, sat there through trial, never said a word about her own issues with being harassed through social media, just like Chris was accused of, shouldn't have been on that jury. She did not speak the truth. And again, if you show up for jury duty and you truly take this serious, because it is serious, someone's life is on the line. Chris was facing a life sentence with no chance of parole. It was serious to him, and it certainly was serious to his family. And keep in mind, too, that his little boy was involved in this. It mattered to Chris that he get a fair trial. Did he? Absolutely not. You can't hear any of that and not be horrified that this person lied to get on that jury and then became the foreperson and found you guilty. Well, Chris's mom hired a really amazing attorney who has been with them for quite a few years now. And I grew to respect Roger Appel in Alabama, amazing attorney. He wrote a motion based on this juror misconduct, and it was mhm, denied. What was interesting is the state's response to the judge's denial. I found this very interesting. I think you'll get a feel for it in a few minutes what Attorney Appel actually argued. So I'm not going to double dip here. This response was written by the Attorney General, Steve Marshall, to the denial of the motion for based on the juror misconduct. He said on March 9th, 2020, while his first Rule 32 petition was pending, Chris filed his second Rule 32 petition in the Lauderdale County Circuit Court, challenging his conviction for sexual abuse of a child less than 12 years old and his 25-year sentence. Chris alleged that the Constitution of the United States or of the state of Alabama requires he receive a new trial, a new sentence proceeding, or other relief. He alleged pursuant to Rule 32.1a that his constitutional rights were violated by jury misconduct. Specifically, he alleged that juror Ashley failed to answer questions honestly during voir dire that would have revealed that she had been involved in a toxic relationship with her ex-husband and that this information was relevant to the facts of the case. On March 11th, 2020, before the state had a chance to respond, Judge Graves summarily denied Chris's second Rule 32 petition. The trial court summarily denied it 2 days after it was filed without giving the Lauderdale County District Attorney's Office an opportunity to respond. Therefore, this court should remand this case to the trial court to give the Lauderdale County District Attorney's Office an opportunity to file a response to Chris's claims. The Lauderdale County District Attorney's Office has a right to file a response in this case. Chris's second Rule 32 petition alleges jury misconduct and is supported by exhibits that include the jury voir dire transcript of his trial that was not part of the record in his direct appeal. And again, it wasn't on the record because it had never been transcribed. On its face, the petition cannot be deemed meritless. Now, that's a roundabout way of saying it has merit. This is the state saying this, saying that Chris's motion, based on the juror misconduct, has merit, and it potentially affects the validity of his conviction for sexual abuse of a child less than 12 years old and his 25-year sentence. Based upon the foregoing, this case should be remanded to the Lauderdale County Circuit Court for the Lauderdale County District Attorney's Office to be given an opportunity to file a response to Chris's second Rule 32 petition. Wow. After I read that, I was very encouraged. In fact, I reached out to Chris's attorney, who was also encouraged. He said, "I feel very good about your research. The AG, in their brief, admitted there was merit to the claim." So in June of 2020, we were all very encouraged. It's rare for the state to admit that we've got something and to want to pursue it. So that was in June 2020. Very excited about it. Praise God. That was short lived. The next month, we got a letter. Well, Chris's mom got a letter from the attorney, which she forwarded to me. And he said, "First, as to your current Rule 32 petition, which we allege juror misconduct, the problem that has occurred is that the state has brought up the point that it is time barred because it was not filed within 1 year of the Supreme Court denying your direct appeal." Now, remember, there was no jury voir dire transcript prior to the direct appeal. So how are you going to allege juror misconduct when you don't even know what was said that day? Then he said, "As you may remember, when I filed your first Rule 32, the 1 year time limit had almost expired." So let me get this straight. According to the state of Alabama, your constitutional rights have an expiration date. Thank you for being a part of this today. Thank you for listening. Thank you for watching. If you know of someone who's going through it or has been through it, could use our help, our contact information is in the description below. Remember, the courtrooms may be silent, but we won't be. So speak up, speak out, and always speak the truth.